clarification. If we haven't gotten it quite right, I assume we'll hear from each and every one of you, and we will do our best to move forward. So with that, let's move to the presentation of cases in chief.
Vice Chair,
Any question? Yes.
sorry, I asked a question that Jennifer may have been about to ask as well. Is your letter order going to address the question of the drainage-only customers, or is that a separate?
Thank you. Yes, we will address the drainage-only customers, although I was kind of hoping to be silent on that, but maybe not. I mean, no, we will address. We will. Our inclination is it's woods, so drainage customers aren't customers of woods, right? Now they might have been.
No. Let's clarify. Woods provides two services for which landowners pay it.
Okay.
It provides drainage services, and so it has drainage customers, and it provides irrigation water delivery services, for which it has irrigation customers. So when you use the term woods customers, it could include drainage-only customers, and those are the landowners we've asked to be excluded.
Right.
Okay.
No, you're absolutely right. But you also are going to attempt to do a map or a listing
We did
as to who those who the customers who get water from Old River
Or Middle River.
For Middle River and get served. You're going to attempt to do that, correct?
We already did that.
Okay.
It was attached to our petition. There was a list of all the landowners, their APNs, and their acreages of who are only receiving drainage service.
Okay.
We can
drainage,
also,
right?
Yes, we can also put them on a map.
Okay.
But yes.
Okay. And, I think just if it's okay, that this could be potentially part of, something that the parties can stipulate to as far as defining clearly who the irrigation customers are and that are relevant to the diversion that is the subject of the cease and desist order proceeding.
We will attempt to do that, but I will tell you we would request a ruling on this sooner rather than later, because if you by chance rule against that petition, we have a lot more work to do before May.
Thank you. No, that's helpful. Can we do that?
Yeah, I think so.
Okay.
There might also be other breaks where stipulation could be reached really quickly today. Who knows who could be faster?
Our goal here, obviously, is to make this as narrow as possible, but not a waste of time, which is the point that Valerie was making. So now to the presentation of cases in chief. The hearing notice for this proceeding provided that Woods customers are the only parties who would be allowed to present evidence, and participation by current parties will be limited only to cross-examination, rebuttal of new evidence, and any redirect examination permitted by the hearing officers. Yet notices of intent to appear, the NOIs, proposing to present a case in chief were submitted by the represented landowner customers and many of the current parties and by Westland's Water District. Given the limited purpose of this noticed supplemental hearing, we'd like to hear comments regarding the noticed limited participation of the current parties and Westland's proposed participation. So let's start with Westland's.
Okay, thank you. So we appreciate where the board has come out on the scope of this, and I'm still not sure that we've ever been on a different page than that. And so we've never sought to expand the issues beyond the rights that Woods relies upon for diverting water in the context of the CDO. and to make the appropriate determinations on that. We think this is, even with the landowner's participation, it's crucial to make that decision. Those have all current relevant data available to the board to assist it as it makes these determinations on whether or not to issue a CDO, whether or not to modify the existing order. And we think that all parties should have the opportunity to present additional evidence, case-in-chief evidence, if it relates to that issue and would facilitate it. And we'd be very happy to, as we've said in our papers and it has been said today by various parties, delighted to work with the other parties about an orderly and efficient manner of presenting that evidence through stipulations, et cetera. But we think that the parties should have the opportunity to supplement the record if they so desire, given the importance of the issues.
Well, let's hear from the. Pardon? Yeah. Let's. Valerie, do you have comments or
Just
Stanley?
a short one that I wouldn't want the remedy of one due process right to end up in a due process violation for another party. So, I mean, again, with how much we open the scope up, we really have to be careful that that doesn't happen. If we're just allowing one party in a matter to present all the evidence and we can kind of throw rocks at it, but we can't provide evidence that has developed, you know, then we're really in the fundamental same position as we were, just that we're violating the due process of rights of a different party. So again, we just kind of have to match this to the scope and how much we're opening it up, and make sure that it's as fair as it can be, kind of across the board. If there's new evidence that the landowners are providing on a limited basis, other folks should also be able to provide evidence toward that same, so long as it's relevant to the issue.
But I guess specifically on Westland's water district is, you know, in terms of being a specific new party to this proceeding. Do you want to address that at all?
Westlands would be in the same position from a standpoint of what its interests are aligned with the authority, and
Correct.
and it's a member of the authority, in fact. And so, thank you. But in any event, its interests are aligned with the authority. We honestly don't know today, as we're sitting here, if there is new evidence to put in. But as Valerie said, again, the due process issue is important to consider. We don't want to unbalance things. And we think that all current and new parties who have evidence to supplement the existing record that is relevant to this very important issue should have the opportunity to put that in as a case in chief and not just through rebuttal, including for Westlands.
But you don't feel like you would be represented sufficiently by the authority? Is that what I'm hearing?
I'm not sure about that, honestly,
Okay.
today. We need the chance to sort that through.
Yes, Stanley.
Yeah, we have focused a little bit on Westlands on this discussion, and I did just want to make sure we all are clear that the other parties who are already participating in the prior hearing, I think, also want to be able to make these sorts of presentations. So I just wanted to clarify, it's not simply Westlands.
Correct. No, I don't think we are confused by that, but go ahead, Steve.
Well, you were a hearing officer prior. I wasn't, but all of the parties that have requested to present cases in chief had a chance to present cases in chief in the prior hearings. Okay, so I think that's where we're wondering if there's an opportunity for a more expeditious hearing, and that new information can be brought up within the limited scope of the noticed hearing, that are a logical outgrowth of the new evidence provided by landowners, which we don't, none of us have an idea at this point what that is. It is our hope, by structuring the hearing in this manner, that your due process needs are met through, an adequate rebuttal process based on the limited scope of the evidence that the landowners bring.
If I may just quickly, I think the fundamental issue that we're all struggling with, right, is that we can all think of evidence, but it's not in front of us, and it's kind of hard to imagine. And as attorneys, we kind of try to do the worst case scenario, thing. So stick with me on this. But if the landowners present evidence on a landowner right, Modesto has historically hired historians and other folks that look at whether a landowner filed a pre-14 notice or other evidence in that manner. If the landowner were to present certain evidence and MID or other parties wanted to also present evidence on that landowner right, and it didn't fit into some sort of rebuttal category, you shouldn't be prevented from so providing. So if they come across evidence or don't come across evidence that we develop, if it's on the new landowner issue, I guess I just don't understand why Modesto wouldn't be able to present the evidence that it finds. You're right, we presented evidence previously on woods generally. But now that we have landowners that are coming forward and talking about specific rights to a specific parcel, we also may be developing evidence that we have on a specific parcel that if they don't present, other opposing parties should have the opportunity to present.
But you can do cross, right?
You can, but you might not be able to get everything in from cross.
Mm.
I mean, cross and rebuttal are somewhat limited. I mean, I guess you could maybe bring it up, but it's not limited at all.
I think Fran is going to be reviewing this later, but in our proceedings, it's different than in court. The scope of cross is not limited to what was on direct. And so if there's a particular landowner that's in the proceeding and you have the ability to cross-examine the new evidence and to present rebuttal evidence,
Right.
I'm not sure that there's
Need
a
another
reason for a
opportunity
case
for-
in chief. I would
I
need some
other reason for that, right?
yeah, I would need some convincing that there's some there.
Sure, and maybe that example isn't the best one, but unfortunately, I think we're forced to kind of make up examples, and in this situation, kind of trying to think outside the box. So if we're going to limit someone and that comes up, maybe the idea is we just need to be really flexible if we do come across that example, or frankly, if you don't make that limitation, then you don't need to kind of backtrack later, and it will be limited. I mean, I don't think they're going to be huge cases in chief.
Thank you. I guess the point I wanted to highlight is what Valerie said, that we are operating in an unknown because we don't know what that evidence is that's going to be coming in, yet at the same time we have obligations to put case-in-chief evidence in through the declarations by a date certain in May, I think is when it is. And so we have no intention, Westlands and our clients, of duplicating the evidence that's already in the record and requiring you to do a do-over in that regard. We think you've already expressed you don't want to do that, and we never intended to ask you to do that in the first place. But it is possible that there is relevant evidence that we have that relates to the particular landowner parcels that we just want to make sure we have the fullest opportunity to present, whether it's through case-in-chief or through cross-examination or through rebuttal. We don't want our ability to participate on these very important issues hampered because it's going to be plugged into some box that for some reason that I honestly can't think of right now, we're stuck with. And so it's just the opportunity for the full participation, and we can absolutely put parameters about it so that it's not duplicative, it's not excessively time-consuming. It must be directly related to what we're doing.
And I don't think we have any intention of putting you in a box in response to, but what we do have, or at least I am not eager to broaden this so wide that you feel obligated to expand the scope I want to, again, I want to keep it as narrow as possible, but definitely not to put you in a box. And I think with Cross and with our much more liberal, open approach to Cross and to rebuttal, that I can't, it's hard for me to imagine, although I must admit I'm not an attorney, so I don't have an attorney's capacity for imagination. Imagine what could come up that you couldn't put into those two venues. Other parties want to make a
Yes,
comment?
thank you, Vice Chair. I suspect that everything that the other parties would want to put on will be squarely within the scope of rebuttal. I'll give you an example. We filed our notice of intent to appear. We listed all of our witnesses. We gave a pretty detailed explanation of what they were going to provide. One of those witnesses is entirely new, Dr. Littlefield, who's a professional historian. I am quite confident that Stephen Wee will have a robust rebuttal to whatever Dr. Littlefield testifies to. And I would imagine that to the extent Stephen Wee has any new evidence that relates to the history that Dr. Littlefield talks about, he will certainly be able to bring that into the record. I have absolutely no concern about that, and I think it's appropriate. What I do have a concern about is we filed our notice of intent to appear with the list of witnesses and their detailed testimony in December. We now have these other parties asking to put on a case in chief with evidence that they have yet to discover. I have to prepare a rebuttal case then. I have, at this point, no notice of what issues they intend to put forth and through what witnesses in such a case in chief. That's a problem. For example, last year, some of these same parties made arguments to the state board about water availability in the Delta certain months of the year in certain year types. If that were to be the type of data and evidence that they would want to put on in a case in chief, I would have serious concerns about that. I would then have to identify a new rebuttal witness, and I think it gets into a significant amount of detail and nuance that's beyond the scope of what's currently noticed for the CDO proceeding. What I am willing to do, though, is to the extent that the other parties have an idea of witnesses or evidence that they would like to put on, that they believe may exceed the scope of rebuttal, if they could get that to us in short order, I think we could see if it's something we could stipulate to, and if we feel like we have sufficient time to prepare whatever rebuttal we would want. Frankly, some of it may be the same evidence we plan to put on. So I'm not sure there's that much disagreement, but it's a matter of timing and ensuring we have a fair opportunity to respond and that we're not expanding the scope of issues beyond what I think that they are.
I would agree with that. To me, I think the board's on the right track. I think it's simple. I mean, the landowners were the only ones who weren't parties before. They're the only ones who should come in with the case in chief. It's simple to me. With the rebuttal and the relaxed standards of evidence here, it's going to be more than adequate. And I'm less optimistic than Jennifer might be to, in terms of reaching a stipulation in terms of evidence that might go beyond rebuttal. I think the rules as they're set forth and the way things happen here, I think that's adequate enough.
I do have some comments and questions, although not exactly on the same topics as everyone else did. Ours are going to be more specific to the prosecution teams. And just a few questions and comments we have. The first one is that the notice, as we understood it, didn't invite existing parties to put on new notices or to put on new evidence. So we do not intend to call new witnesses or provide additional evidence for the prosecution team. We are, of course, going to have our witnesses be available for any and all cross-examination for all purposes. But that brings me to my next question, which was that I believe it was Woods and the landowners listed our witnesses as their witnesses as well on their revised notice of intents to appear. So after you decide the first issues that were raised to you, and we're getting more into the nuts and bolts of order of proceeding, we would definitely like some clarification on whether it's sufficient that our witnesses be used just as our witnesses, or whether other parties intend to call them anew, and how that's going to work out. And then I'd also separately suggest that we maintain largely the same order of proceeding, such that the prosecution team put on its evidence and its case in chief first, and so that our witnesses would be called for cross-examination first, unless you felt that all new evidence should be put on first. Because if only some parties are putting on new evidence, then you have the question of whether the case in chief goes first and then all cross, or whether you just dispose of the prosecution team's witnesses in as much as we don't have anything new to say and haven't been invited to say anything new, and we'll just respond across. So I wanted to raise those issues that are meaningful to us, and we don't have a strong opinion as to how everybody else's go. I think that you've already addressed the fact that the board's rules allow for everything we could imagine to come in, but that's up to you. So thank you.
And we will be getting to the order of presentation toward the end, and so we will, let's address it at that time. Any other questions from Mariana or Steve?
Sorry, just one more question. And I understand that to some extent the position of desiring to have a case in chief is a protective position for the client, not necessarily that you have evidence that you want to present in a case in chief. But are there any specific, you raised due process concerns? My initial thought is that, you know, the landowners, as Dean was saying, that the landowners would be the only new parties. Everyone else has had a chance to put on a case in chief. I can't think of a due process case or rule that suggests that, you know, upon reopening that the original parties should put on a second case in chief. And I'm wondering if you have something like that.
No, I think I agree with a lot of what you said, and it really depends, frankly, on the amount of evidence that you're able to put on. I think what you're saying is if you can get it in a different way, is there a due process violation if it's not up front? And I think you're fundamentally right that there wouldn't be. And again, because we're all kind of trying to imagine what we can't imagine is going to come down to the line, it's very possible that we present all the evidence that we need to in a different form. And I do agree with you that just in general, as a protective mechanism, it'd be nice to just have that avenue open. I'd rather have it open than closed, frankly, knowing that we're going to be narrow and limited. But having said that, I do agree with your point that if we can get that evidence in another manner, I don't think there will be a violation. If we could all see the future and that would happen, I don't think there's an issue. But you know, there may be some situation that comes up, and from my perspective, I don't know why we wouldn't have it open and limited, and rather than just close it off. But again, I agree with what you're saying, that if we can get it in a different way, I don't think there would be a violation.
I guess the reason for keeping it limited is, in my opinion, is to give all of you some certainty as to what you have to prepare for and present. And I realize you are more at a disadvantage in the sense that you're not presenting any new case in chief. You're going to just be prepared for what is presented new.
Right, but if I may, to that point, Jennifer's point comes to mind of if we actually have to provide a case in chief and put that up front, then she'll prepare for it. If we do all this on rebuttal, so if your point is to have it all up front and have people prepared for it, then we would be allowed to have a case in chief. That would promote that concept. Now, I understand the flip side of that is it might get unruly and it might open it up too much, but I think that's what you have to weigh. Certainly Jennifer's point of if she doesn't get to see that and it's all on rebuttal would perhaps frustrate your point of putting it all out there and making sure everyone's prepared. So I think, frankly, those are just two things you have to weigh to come up with that. So.
Okay.
I do have a suggestion on that point. I commiserate with the other party's position to a certain extent. I don't see how Stephen Wee can prepare a rebuttal report that's turned in on the same day that Dr. Littlefield turns in his report, and that really doesn't make a lot of sense. So there probably should be some restructuring of the submittal deadlines so that the landowners submit the proposed testimony and list of exhibits, and then the rebuttal cases follow like a week or 2 weeks later. And I think that makes a little more sense. Otherwise, I'm going to get something from Stephen Wee that frankly is not very meaningful, and he's going to have the ability to potentially respond to what's in Dr. Littlefield's report, and I would only see it at the hearing. So to the extent we can stagger those, I think that makes a little more sense. Also, to Mr. Rose's point, I entirely agree with something he said. I like the idea of having the witnesses come on, at least his witnesses, in the same order that they came on in the original hearing, and having the cross-examination occur at that time. So the prosecution witnesses would take the stand. You would be familiar with their prior testimony. I would have the opportunity then to examine them, and as you mentioned, my examination could go beyond the scope of direct, so I will get what I need to from them. Frankly, I think it'll be super short, and we may not even need to call them at all, but that does make a lot of sense to me, so that you can refresh yourselves with how the evidence came on before. We have the opportunity to cross-examine that evidence, and then put on our own evidence as well, and go from there.
Thank you, and I agree with you about getting information in early so that you can be prepared as best we can. We'll have to see if we can find schedules that work, but for you. But I agree.
Yeah, and actually, we're going to discuss the middle deadline later
Exactly.
today, so we can take up that idea, which I think is compelling.
Okay. Dean, I need to clarify as to whether Woods does not want to present a new case in chief.
If we're going to go with this limited approach, which I think we should, then no, the landowners would be putting on the case in chief. It would not be. It would not be a new case in chief by Woods.
So thank you very much. So the only new case in chiefs will come from landowners. We'll discuss later about getting information in. We will not allow Westlands as a new party to this, but I think they will be well represented by the existing groups. Yeah, both, and so that's I think. Do you agree, Steve?
Yes, I agree. That's the ruling.
I'm sorry, I missed what you said about you're not going to allow Westlands to
participate as a party.
to participate at all as a party,
Right.
even with cross-examination, rebuttal, arguments.
Yeah, they're not a current party.
Right. We're not adding new parties to the proceeding, except the landowners. Right. We're trying to keep this as narrow as possible, and I am positive that Westland should be able to make their points as you all discussed.
Yeah, And
what is needed.
the basis of that ruling is that Westlands does not meet the limited notice qualifications to participate as a party, that is either being an existing Woods customer or a current party. So that's the logic.
So let's move on to the scope of the direct testimony. The submitted NOIs by the represented landowners appear to propose new direct testimony being submitted for from several expert witnesses who previously provided direct expert testimony during the 2010 hearing. The subject of this proposed testimony for Kenneth LaJoie, Donald Moore, and Terry Pritchard appears to be identical, at least as we're reading it, to the 2010 testimony. Consequently, we're concerned about the repetitiveness of this. As you can tell, we want to make this as crisp as possible. But our concern here is regarding direct evidence, not about the availability of these witnesses for cross-examination. So we would like the represented landowners to comment, if you would, on our concern, and go down your NOI witness list, if you can, pretty quickly, to explain how the proposed testimony and evidence will not be repetitive, because that's
Yeah.
trying to get we don't want to do that.
And I do not plan to do that.
Okay.
I've got 4 kids and plenty of other work to do, so I do not need to repeat any.
Or, oh my goodness, Valerie, do you hear
So
that?
but you can rest assured that there will be no waste of time by me. Mr. LaJoie and Mr. Moore probably will not be called as witnesses. At this point in time, I think we're going to rely on their prior testimony. I don't see a reason to call them again. You know, I have to say, you know, I have to reserve, of course, in case something comes up with something another party puts in. But at this point, we don't plan to bring them in again. We're going to rely on their prior testimony. Mr. Pritchard, I do have something new that I want him to describe on the stand, but again, not duplicative of what he said before. And I have a reputation for getting my witnesses on and off. So I guarantee you that if it can be done quickly, it will be done quickly, and there will be no repetition.
Hi. Okay. There are a couple other witnesses that also were in the prior hearing, and we weren't sure if you were going to be calling them as your witnesses or as cross. So there was the people, the expert witnesses, that had the long time blocks that we were most concerned about. But then also we had questions about the prosecution team witnesses, and I believe Timothy Grunsky testified in the last hearing as well. And I was wondering if you could just run through, and clarify. It sounds like there have been some changes maybe since you submitted this NOI, and just sort of clarify where you are at this point, because it is, it's about 20 hours of testimony on here.
Yes. So Tim Grinsky, one reason I did put him on here is because we had this issue with the drainage customers that I wanted him to be able to describe. There are also, you may or may not know this, but in the last 5 years, Woods did install measurement devices and has data. And so he may testify about that. But again, it would be non-duplicative. Who's the next one that's testified before? Was it Mr. Cordaroli? No, he didn't testify before. He is the same as Mr. LaJoie. Yeah, I just discussed him.
The prosecution team witnesses.
At this point, I imagine it's just going to be cross-examination. And actually, I'm thinking that through the stipulation process, we may even obviate the need for that. But again, it would be very, very limited.
Okay, in the follow-up letter that we will, where we will be clarifying scope, we'll emphasize new And I think that will take care of adjustments here. Do we need to get re-estimates of time? Would that be helpful?
I think that would be helpful, but if there's a stipulation, I think it might, maybe we could ask, as, it might make more sense to ask for new NOIs sort of after that point, if that's necessary, or if there is a stipulation, it might clarify.
I will suggest that we obviously have to be conservative when we filed these in December, but we're not far enough along at this point for me to provide you a more detailed or specific time estimate. We will be after we go through the stipulation process and after these witnesses prepare their testimony. So we probably should set a time after the submittal of testimony to have another one of these kind of meetings. Hopefully it'll be shorter, so that we can resubmit estimated times and make sure that we calendar the appropriate times for the hearing.
We're happy to participate however we need to streamline the process.
Thank you. Good suggestion. Thank you. We'll move on then to stipulation as to matters not in dispute. Because the existing record is extensive and the proposed testimony appears to cover subject matter already in the existing record, we want to, and we're open to providing comment, anyone providing comment regarding the possibility of entering into a stipulation, which you've offered to several times, and that's quite helpful, and to offer an opinion as to when a stipulation could or should be submitted for and any foreseeable timeline. So you've gotten to that. Do you want to restate anything or?
Sure, and I did speak to Mrs. Diebenbrock about this concept. I've spoken to Mr. Rose about this concept. We're all in favor of stipulations.
Okay.
We should come up with a timeline. I suspect the parties could confer about stipulations, a meet and confer process in February, and preferably by the end of March, we would have those stipulations nailed down, because that would enable us to tailor the written testimony that will be submitted in the beginning of May based on those stipulations. What I don't want to have happen is we spend all this time on testimony and then start the stipulation process thereafter.
Right.
That's just a waste of resources. So we should do the stipulation process in sufficient time that the written testimony is then prepared based upon it.
Dean, you have any comment? I assume that's okay with you as well.
That's perfectly agreeable.
Yeah.
Yeah, we've talked about that.
That is,
You want to like take more time, right?
we actually, the timeline that Ms. Valletta referenced is exactly what we have in mind as well.
I think it'll save everyone lots of time. Now, I assume you agree. Okay, good. That's great. So now, time limits. The landowner group A and B. Okay, so we'll handle time limits after the stipulations and after the testimony, and so that would be probably in the. Well, we'll figure it out. I mean, you'll be sending us probably, hopefully, sending us new time limits that are much lower than 20 hours.
Yeah, I would recommend that you request the parties submit a revised notice of intent to appear at the time that they submit their list of exhibits and testimony,
Yeah.
Okay.
and then that we hold another pre-hearing conference as soon as all of those submittals are received, and we go from there.
Thank you. That's I agree with that.
That's
Do you
a good
agree?
suggestion, yes.
Yeah. Okay.
I was going to suggest something similar.
Should we check with Michael to see if he's done heroic things with trying to schedule conference rooms and whatnot? Does that seem feasible?
Well, yeah. Right. Go ahead.
I think we can definitely attempt to do that. I of course don't know right now what scheduling will look like. I think we can do our best if we all just commit to make it as brief as possible. I think the shorter the
It
time period.
shouldn't take long. No.
Right, the shorter
This is the hard part.
Yep.
I guess, I mean, I love the suggestion of submitting the revised NOIs with the written testimony. But I could see the possibility of not needing to do another pre-hearing conference. But just on that specific narrow topic.
Can I ask for clarification on that? I think that you had already ruled that the cases in chief would only be from the newly added landowners. So would anybody else need an amended notice of intent to appear besides the landowners who already submitted theirs? And how's that going to relate to the stipulation? I mean, I'd like to see it so that when we go looking for what's going to happen, it's on the NOI. But I just want to keep track of what we're looking at for what comes where.
Maybe NOI is the wrong term.
Right, it is.
Because we're going to submit, the landowners will be submitting the testimony on, I think it's May 8th. And then I assume you're going to be setting a time thereafter for any other party to submit their rebuttal testimony. Then at the time that we submit our written testimony and at the time the other parties submit their rebuttal written testimony, we should probably also just submit a revised list of witnesses and time estimates.
That's right. We were shorthanding when we were saying NOI. Sorry, that was my error. Really meant revised time estimates along with the testimony that you had previously submitted.
Sorry, I have a question on that, a clarification. So are we saying that rebuttal evidence is going to have to be presented ahead of time or not? In the notice it says it wouldn't, and now are we talking about having it?
Yes.
Okay.
Because I think in the end, it will save us time. Everyone will know at least most or much of what they need to be prepared for, and the more prepared we can be, the more expeditious we can be. So that it's coming up later, but that's my thinking at the time.
That's right, and it is on our agenda here to discuss, and the idea of a staggered submittal deadline is a new idea that we can incorporate into that discussion and get your opinion on timing.
So I just again, just to confirm that opening statements for parties with no case in chief will be limited to cross-examination and rebuttal, as we've discussed, and any redirect examination permitted by the hearing officers, and we will have that opportunity. As such, only those giving new evidence will be permitted opening statements to frame such evidence. Now, to order of presentation, and this gets to something that David had raised earlier. As I heard the recommendation from David, but you all weigh in, that we would present the, seems like we will need to present the landowner's case in chief first. Is that not correct? Is that what
I actually think it would provide a better context to allow the prosecution team's witnesses, because they presented the only case in chief, really, or the main prosecutorial case in chief, for them to take the stand first if necessary for examination. And then the order from there on, I'm not sure it matters too much.
Okay, that works for me. I just hadn't really thought of it that way.
I think that's right as well, and the reason I do is because my assumption, and perhaps it's incorrect, but my assumption would be that the prosecution team would be presenting some sort of CDO or draft CDO, and that's what they would be presenting evidence to support. I don't know how much it will talk about specific landowners compared to woods, but if we don't have kind of a centered presentation from the prosecution team on how that's going to go, then I don't know how all the evidence falls out after that. So I think the prosecution team, in my mind, is going to have to present something, and it's going to have to touch on the landowner's rights in some capacity in this new CDO. And if it doesn't, I don't know how we go on from there. So, I mean, it makes sense to me for them to go first.
If I could jump in, I certainly, I wasn't understanding that the same way in terms of order of presentation as Valerie was just proposing, because we don't intend, and I don't think we were invited to present anything new. We were just going to provide our witnesses for cross-examination. My proposal for the prosecution team going first for its witness cross-examination was simply because we had originally proceeded first and provided our evidence first, and as Jennifer said, it may recenter everybody to how we began, but I expect that the cross-examination of the new witnesses would occur after the direct examination, and so I don't see one has to go after or before the other, but my witnesses would probably appreciate, and one of them has since retired, and that doesn't give them any additional weight versus anyone else's, but they would appreciate to be done, and since there's nothing new coming from us, or we don't expect to put anything on new, we didn't understand that we were invited to, then if they were just gotten out of the way, again, it might recenter the issues to how we began.
And I don't, we're not asking for new, but we're asking for first, setting the context.
This would be, could you describe that as a summary or kind of an overview presentation?
We can put on a presentation if you'd like. I don't know. I think that's gonna come as to how we want to kick this party off. If you want to have us just step up and put our witness on the stand and say, and go to whomever wants to cross-examine them, then that would be consistent with a continuation of the proceeding that's already begun. If you wanted the prosecution team to provide something that's not an opening statement but is how we got here, I think it might be biased, or everybody else would want the same opportunity. So I'm not sure if we would be the ones to frame how we got here the same way we did the first time. I'd be happy to do whatever you'd invite us to do, but everybody else would probably want the same opportunity.
Okay, so I was just consulting with Mariana, and if we all do our jobs of reviewing the evidence, the framing should not be necessary. Now, for those who are listening on the webcast, and reading the documents that come from that, they may have some questions, but we will just refer them to the extensive body of evidence that's there. Okay, so the way I have see the order of presentation, it would be the prosecution team would be first, and you would have an opportunity to do cross, and then the landowners would come next, and there would again be cross and then rebuttal, correct?
I think we're missing the ability for the landowners to cross-examine the witnesses of the other parties. So
Correct, okay.
we have the prosecution witnesses, which will take
Okay.
the stand first. We'll have the opportunity to cross-examine them. Others will have opportunities, I imagine, as well, if we raise something new. And then next, any other witnesses that were put on by the other parties, for example, Mr. Wee, would need to take the stand so that we could cross-examine him.
Before your,
Honestly, I don't think
I don't think it matters.
I don't think
agree.
it matters. I don't mind if I cross-examine their witnesses first or if I put my witnesses on first. To me, you're going to listen to it all. So, hopefully I get to do all my stuff before lunch, not after. But, other than that, it honestly, I don't think matters.
Do you have a preference as to whether you precede or follow the landowners?
I'm sorry, if our cross-examination of the prosecution's witnesses,
Well, you'll be, we'll do the prosecution.
correct, and then all parties can cross-examine those
Right.
witnesses.
And
as
if
they're-
you have any,
No.
okay, so then it'll be landowners, yep.
So cross
You'll be
the
next.
prosecution's witnesses only by the landowners, okay? And then the question, I got lost.
Well, the question is, they may want to cross-examine, the new landowners may want to cross-examine the
Our
previous
witnesses.
witnesses that were here.
And do I have a preference if they do that before they put on their own case in chief?
Correct.
The only concern I have about that is efficiency,
Right.
because we may want to put those witnesses on in our rebuttal. And so it's just, if you don't mind witnesses taking the stand multiple times, we can work with that.
Okay.
So our concern is just efficiency.
Okay.
That's a very good point, actually.
Yeah.
So to be more efficient, it might make sense for the landowner's
To go.
case in chief to follow
Mhm.
as the second act in the
I like that.
play. And then after that, to have the other party's witnesses take the stand, and they will take the stand for potentially one or two purposes. One purpose being providing rebuttal testimony, which would be elicited through examination by these attorneys to rebut anything that was put on in the landowner's case. And the second purpose would be for the landowner's attorneys to be able to cross-examine them as to anything that they testified to previously or their new rebuttal testimony.
But there may be, I would think there would be possible cross-examination by the parties of the landowner case.
Oh, yes,
Also.
but that'll happen with each witness that takes
Exactly.
the stand.
Exactly. Okay.
And we understood that, and I liked the second act in the play, the reference to that. As part of that second act
Yes.
would be the other party's ability to cross-examine the landowner witnesses.
I think if we're going to go with that structure, the only thing that we'll need to pay attention to, and that will be easy for us, is the scope of cross-examination of each witness. Say, for example, the contractors and those parties' witnesses that were put on before. I suspect that this is a unique position that we have because we're not new parties. If I understand correctly, the prosecution team would have the ability to cross-examine on any rebuttal evidence that was put forward, but would not be cross-examining, because we're not a new party, on anything that happened previously. So there's going to be a distinction that might be made clearer if there was a different order of presentation, but that would mean people coming up more than one time. So if we can clearly draw the line, and it may only apply to the prosecution team, but it may apply in different ways, then I think we should clarify that. I don't have any issue doing so. Does that make sense?
Oh, I'm sorry, Dean.
Oh, yeah, that'd be the same thing as for Woods. Woods would then have the ability to cross-examine any rebuttal evidence
Okay.
that the former parties put on.
Okay, and yes, go ahead.
As we were concerned that there is this potential for it to get so complicated here, and maybe the stipulation process, the meet and confer process will facilitate this. But a point is, we don't know if the prosecution will put on new evidence. And if the prosecution puts on new evidence,
They have already